Good afternoon to the panels and members of the floor. Before the presentation begins, let us introduce ourselves. I'm Kirti, the moderator for today. Our first panelist is Miss Fazliana, second panelist is Miss Aisha, and our third panelist is Mr. Afiq. Our forum today focuses on customary international law, which is one of the sources of international law. According to Article 38 of International Court of Judicature, states that customary international law consists of rules that come from a general practice accepted as law and exist independent of treaty law. So therefore, customary international law has two elements, which are it should be a general practice and also it should be accepted as a law. Okay, now without further ado, let's welcome Miss Fazliana to present about what is state practice under customary international law.
Hello everyone. So, under state practice and the customary international law, the society and the rules are bound together. One could not have games, for example, without rules. Customary international law refers to binding legal rules that have developed on global or regional levels through continued practice. The test of the existence of a customary rule of law is the extent to which it is observed in the practice and behavior of states. Although these may not seem a fuzzy or imprecise, imprecise concept, it provides for flexibility. Thank you.
Thank you, Miss Fazliana. Could you give us an example of state practice under customary international law, please?
Okay, for example, an emergency and eventual adoption of the exclusive economic zone in the law of the sea. A measure of state practice may be provided by an array of instruments, including treaties, declarations, agreement, and other pronouncements.
Okay, thank you. Miss Aisha, would you like to add a few things about the state practice?
Furthermore, several criteria, including the number of states that participate in the activity, may be indicative of state practice, which is national legislation demonstrating acceptance, decisions of national courts, positions adopted by ministers, diplomatic representatives, and legal opinions of government lawyers, submissions by states to international courts and tribunals, and lastly, diplomatic materials and communications, the travaux preparatories of international conferences and negotiations.
Thank you, Miss Aisha. Um, Thank you for explaining about the factors, about a few things, extra information about state practice. Now let's move on to the second questions, which is about opinio juris. As law students, we have heard about this term quite many times, but can Mr. Afiq explain briefly about what opinio juris is? Thank you so much, Mr. Afik. So, what you explained was more towards what opinio juris is in international law. As for a general meaning of opinio juris would be opinio juris is an opinion of law or necessity. Okay, now let's move on to the third question. Miss Fazliana, can you explain the definition of jus cogens for us?
Oh, okay. So for jus cogens, also known as the peremptory norm, is a fundamental and overriding principle of international law. It is a Latin phrase that translates to compelling law. It is absolute in nature, which means that there can be no defense for the commission of any act that is prohibited by jus cogens. The principle which formed the norms of international law cannot be set aside. It stemmed from the idea of a binding law, which would be in alignment with the natural law and would render contrary customs and treaties invalid. This idea led to the existence of hierarchical superior norms that would invalidate the treaties and customs. The doctrine of jus cogens was initially defined in Article 53 of the Vienna Conventions on the Law of Treaties 1969. It was later stated as a customary principle, but Article 53 of the Vienna Convention, however, contains no reference to any element of practice. Thank you.
Thank you, Ms. Fazliana. So you have explained to us about jus cogens and also related it with Article 53 of the Vienna Convention. Um, can any of the panelists share your thoughts and examples on the principle of jus cogens? Miss Aisha, maybe?
Yes, Miss Christie, I can.
Thank you.
Jus cogens imply absolute restrictions on genocide, slavery or slave trade, torture, or other inhuman treatment, prolonged arbitrary detention, and racial discrimination. Any activity or treaty carried out by the states or international organizations that contradict human dignity and rights will offend the concept of jus cogens and thus be void. It can be said that jus cogens exist to protect and uphold human dignity and rights. Thank you. That is all.
Thank you, Miss Aisha. Now we have discussed about the terms that is quite familiar and closely related to customary international law. Now, let's move on to the cases. So, all in all, what cases can be applied to the matter that the panels discussed just now? From my research, I found the case of Colombia against Peru, which is also famously known as the asylum case. Can Ms. Fazliana explain further about this case?
Yes, I can. So in Colombia versus Peru, the ICJ recognized that the scope of Article 38 of the Statute of the International Court of Justice encompass bilateral and regional international customary norms as well as general customary norms in much the same way as it encompasses bilateral and multilateral treaties. The court also clarified that for customs to be definitively proven, it must be continuously and informally executed. Thank you.
Okay, so for a customary law to be recognized, it should be continuously and uniformly executed and practiced by the states. So, are there any other cases related to the international customary law, panelists? I think Miss
Yes,
Aisha.
Miss Kifty. In fisheries case, in the case of United Kingdom against Norway, which is an indicator of persistent objective, a state may contract out of a custom in the process of formation. Objection must be clear. In this case, Norway was allowed to enforce her system of wider
Mm.
Yeah,
Miss
okay, that
Aisha?
is all for
Okay.
me.
Ah,
Thank you, Miss Aisha, for sharing about the fisheries case. Now, I've just found another case about Nicaragua against United States in 1986. Could someone please explain about this case? Thank you, Mr. Afik, for sharing the case of Nicaragua against United States. So now we have come to the end of this forum. I'd like to close this forum by thanking all of the panelists for their participation in this forum today. I would like to thank all of our panelists today for the informative and interesting talk. With that, thank you for your attention. Thank you.
thank you, everyone.